to Immigration Law and Policy Q&A with Nicolette Glazer. First, I wanted to apologize. I haven't been able to talk to you for a while. I had been a crazy few weeks, but I am back, and I was thinking I want to talk to you today about few of the cases that seems to have a lot of interest. They generated a lot of interest. One of it is the Mahmoud Khalil case. This is the case of the Palestinian born activist from Colombia who was arrested, I believe, last weekend. And it's a case that is of tremendous importance to anything related to immigration and what is going right now. And the second case I wanted to talk to you about is the case about the effort of the Trump administration to actually use the relic, that is the Alien Enemy Act, to send people, specifically Venezuelans, to El Salvador. They did so. And so I'll talk to you about that particular case and what is going on. And if you have questions, I got some. And if you want to send it, please do so. You can do so on X, or you can do it on Instagram, and I'll try to respond. Okay, guys. So first thing, I'm going to go with the Mr. Khalil's case, which is an incredibly interesting case for purposes of immigration law, and what we will probably keep on seeing as this clear indication and a pattern that they are going after activists first, and specifically immigrant right activists who do not have, obviously, citizenship. And second, with respect to a lot of students who, because of confirmed or non-confirmed reports for participation in either a political events such as protests, marches, whatnot, or based on their social media activities, appears to be a target of these organization, of this administration. So that's why I said this particular case has this tremendous implication for whether courts will step in and prevent the Trump administration from using speech and conduct to basically strip people of either non-immigrant status or even green card. Because one thing I want to make sure and repeat over and over again, just because somebody has a green card does not insulate that person or immunize them from being placed in removal proceeding, being arrested by ICE, or ultimately being deported. In fact, that happens daily, if not every hour, in immigration courts across the United States. So that idea that you have a green card or somebody has a green card and ergo they're doing something illegal, that is definitely not correct. And it is an exaggeration, and to the extent that, obviously people can say anything they want on social media, but to the extent that people do see some posting to that effect and think, oh, because I have a green card or because I have a lawful visa, anything the government does, that necessarily means that they're doing it unlawfully. Not so. The Immigration Nationality Act actually gives the government tremendous amount of discretion and authority to engage in a lot of activities that will not be acceptable if done against U.S. citizens. So if you're non-citizen, until you get your citizenship, you are naturalized. Basically, the government could go after your green card. They can place people in deportation proceeding, which now is called removal proceedings, and they can detain people for the duration of these proceedings. So this is what the law is currently. So that is ripe for tremendous amount of abuse, and this is what is happening. So let me tell you about these two cases and kind of make some commentary about it. And again, those are not cases I'm involved in anyway. I do not know anything about the facts other than what is being publicly disclosed in court filings and commentary by parties with firsthand knowledge. So anything I'm saying is entirely in the public domain. So, but also it's very limited. So there are a lot more information that probably will keep trickling down that will kind of place these cases into focus. So that was a disclosure I wanted to make for you guys. So the first one is Mr. Khalil's case. So from what has been disclosed, Mr. Khalil has entered a few years ago on a student visa. He was a student at Columbia, postgraduate, and he completed his studies, I believe, sometime in December last year, and he's due to graduate sometime in May. So if he only had student status, he would have remained in valid student status until graduation. But he is also married to a United States citizen, and he obtained his green card sometime towards the end of the year, maybe November, December, not sure. So as you may know, people who have entered with a visa, meaning they've been inspected and admitted, if they are married to a United States citizen, the United States citizen can petition the non-citizen for a green card, a process called the adjustment of status. And as part of this process, there are forms that are filed. People go for an interview. Sometimes interview is waived, but the person will receive a conditional green card if the decision on the application is done within 2 years of the marriage. And it sounds like this is the case here. So I presume that Mr. Khalil had a conditional green card. A conditional green card means it's a green card that is valid for 2 years. And then prior to the expiration of these 2 years, the spouses have to file a joint petition to remove the condition and make the green card permanent. But for purposes of rights, whether you have a conditional green card or a permanent green card, you are entitled to the same protections and you have the same right, meaning you are employment authorized, you have the status of a legal permanent resident in the United States, you can freely travel and return into the United States, though you are continued to be subject to inspection. However, unless you have been outside of the United States for more than 6 months, or if events have happened since the departure, then there's a full inspection. Otherwise, people basically go through secondary, sometimes primarily through primary inspection, but they are readmitted as legal permanent residents. So that's kind of basically what the status this gentleman had. What happened is that he happens to apparently have been the lead negotiator or some sort of a representative of the student segment that engage in protest and some very destructive activities last year at Columbia University. So maybe you have seen some of these reporting at the time, or they continue to have a ton of that still going on, and the rebroadcasted prior videos and recording, etc. But what happened is that as a representative, obviously he had some sort of a notoriety, and that made him a much easier target, primarily because I suppose that's the thinking of the government, is because he was somewhat of a representative or a negotiator with the administration during that process. He somehow is espousing all the opinions, all the speech during this protest, and the conduct that clearly was not a protected conduct, such as destruction of property, taking over buildings, and harassing other students. So this is basically why I believe the government went after him, because he was sort of the face of these protests, which obviously involve a lot of free speech. However, based on what I saw in reporting, I'm not have not on the spot. I didn't see it, but from what I've seen last year, and from talking to people, I can tell, in my opinion, there is hell of a lot of activity that went on those campuses that are not protected free speech, that went beyond that. And specifically, there was activities that is clearly infringing on other people's rights. Now, whether Mr. Kirill involved in that kind of activity or not, I have no idea. And none of them has been presented into evidence at this time. So my suspicion, and the way I saw reading between the lines of the filing so far, it appears to me that he was targeted because he was the face of that protest. Now, at the same time, it appears that some information is coming through, and I don't know if it's been confirmed, but I saw a letter that he wrote, was attributed to him, that was publicized yesterday, that suggests that he was there was a discipline imposed on him as part of these protests, that he may have been suspended and then reinstated. And so there appears to have been some disciplinary action taken by the university. Now, my suspicion is that that information about his disciplinary file probably had been shared with ICE, or ICE had access to it. So I presume that in addition to what was available as public information and part of surveillance and police videos and reporting or whatnot, they did have access to internal documents, specifically his disciplinary files, which probably was part of them using it as showing that he had engaged in activities that have crossed beyond the line of a free speech. So what they did is, as part of the publicized new policy of the administration, that they will go after people that they see as violating the prevention of anti-Semitism executive order that was enacted, I believe, maybe 10 days ago, that they are going to use that as a official policy of the administration and target non-citizens for either expressing such views or engaging in activities that amount to anti-Semitism or are a violation of the Civil Rights Act. Now, concurrently almost with this executive order, and perhaps not coincidentally, Senate, about probably a day or so after Mr. Khalil was arrested, passed the Hamas resolution, which passed unanimously and contains the view of the Senate as to what the Senate perceived as a violative activities on part of Hamas. Hamas has been a designated foreign terrorist organization since, I believe, 1996 or 1997. So obviously any activities or a large, very broad activities that will never be considered terrorism in regular parlance or under the Patriot Act per se, for example, will be considered what's called a trig, or terrorism inadmissibility grounds, for purposes of initiating removal proceeding or excluding non-citizens based on terrorism grounds, which was a ground of inadmissibility that was placed in the Immigration Nationality Act in 1996 in conjunction with IRA, and then was amended and expanded in the Real ID Act and the Patriot Act. But what's interesting is that in Mr. Khalil's case, the government did not invoke the terrorism ground for removability and inadmissibility, which they very easily, in my opinion, would have been able to sustain in this case. But instead, they went and used a different ground of inadmissibility and deportability, which is to prevent people from entering or remaining in the United States because that will be a violation of national security and foreign affair or foreign policy of the United States government. So a very amorphous, very undefined ground that was put in basically to protect the vast discretion of the executive in the realm of national security and foreign relations. It is a very rarely used ground for inadmissibility, but it is not that rare that they are writing on a blank slate. In fact, there is a binding Board of Immigration Appeal decision that addresses that ground on inadmissibility. There are older decisions. There are several unpublished decisions that address issues within the Executive Office Immigration Review, meaning what is binding on the immigration judges. On the district and federal court, it's a little different story, but I'm not going to talk about that. So it's very, very strange and very amorphous provision of the Immigration and Nationality Act, but it is a provision that certainly can be invoked as long as procedural steps are taken, which requires the Secretary of State made a formal determination about it. But because it crosses the line of speech, Congress, when it wrote the provision, specifically said that the provision cannot be invoked if the sole ground for it is basically protected activity, speech, beliefs, things that are sort of subjective, that did not go into conduct that is violative in any policy, unless the Secretary of State again make a determination that there's something more. And so even pure speech or pure beliefs could be enough under this provision, but the Secretary of State must inform certain congressional committees. So in essence, Congress said, well, we're going to give you national security as a catch-all if you want to go after certain people that you don't like. But we're going to pay lip service to free speech by putting into the statute that you cannot go after people solely on account of free speech. And then Congress, of course, took it away by saying, even if it is just free speech, we're going to let Secretary of State have the final say, but he has to do an extra writing to Congress to notify them that they are taking this step. So it's, again, a very opaque provision that provides little security or due process or safeguard for the person or the subject of such invocation, and tremendous amount of discretion to the executive, specifically the Secretary of State. Now, what happened in Mr. Khalil's case is that Rubio went in and said, this is the policy of our government. If you are supporting terrorism organization, or if you are going to be coming to the United States and participate in protests in support of Hamas, Hezbollah, or any other their designated terrorist organization, we are not going to allow you to be in the United States. That's pretty much what he came in and said. And he made the commentary about something like, if you tell us that on your application for a visa, we are not going to let you in. Now, if you didn't tell us that and we gave you the visa not knowing your opinions, belief, and political affiliation, and you get into the United States, then we're going to use that and going to strip you of your visa and go after your green card. So that's what exactly they tried to do. Their blueprint is that Mr. Khalil is a Hamas sympathizer. That's what they called him. And he did not disclose his support, his affiliation, membership, whatever, with Hamas when he applied for his student visa, because there are certain questions that are asked that ask for your political opinion. Have you engaged? Are you supporting a terrorist organization? I mean, there's a ton of these very broadly worded questions that are asked on all immigration forms. And so if the person says no, obviously they shut off a line of inquiry. So under the immigration law, if you're asked that kind of a opaque and vague question and you say no, but then information comes down the road that raise question as to whether you were truthful, then the courts will say, well, that answer of no is shut down a line of inquiry from the officer. So you have made misrepresentation or you lied, and that lie is material, and so that will render you inadmissible. So it's a very powerful, again, option that consular officers have in denying visa, and that carries it to the ICE, USCIS, and immigration court if the person actually gets into the United States and admitted into status. So that's kind of where the whole idea that the Secretary of State put in and applied it to Mr. Khalil because they wanted to use him as the blueprint or the face for these crackdown on sympathizers. And so what they did is that they obviously surveilled them. So they knew exactly where he was. They knew when he was coming home. And so they approached him before he got into his dorm with his wife, who apparently is 8 months pregnant. And she's a US citizen. And so they asked him for his name, confirmed his identity, and told them that they will be taking him into ICE custody because his visa, student visa, has been revoked. Well, apparently, in the haste of doing this targeted arrest, the ICE officers that were involved did not even bother to check or run a check on his immigration status with USCIS. And so they were surprised, according to the petition, when they learned that he is not just a student, I mean, an international student here on an F1 visa, but he actually holds a green card. And so when that information was provided to the arresting officers, apparently they appeared surprised. And they made off-the-cuff remarks saying, well, that has also been revoked. Well, as I said, Secretary of State Rubio has the authority to revoke visas at any time. This is obviously nothing questionable or unlawful about him taking the position. Unfortunately, once there is a facially valid exercise of that authority, there is very little that can be done to go beyond to probe the reasons for it. So revocation of visas happen all the time, and it's not that unusual. What's unusual is that the revocation here happened years after the visa holder was admitted in the United States. Most of the time, visas get revoked after they're issued, but before the person departs, or even sometime while the person is en route to the United States because the consular officer learns about something, or there's a variety of reasons. But, it is much more unusual to have a visa revoked once the person is here in the United States because it kind of has limited value, that revocation for somebody who's here, because the visa is, think about it as a ticket. It guarantees you that you can be will board your plane and come to primary inspection. That's all that it guarantees. The visa that does not guarantee admission, and people can be denied entry even if they have a valid visa. So once people come up with that ticket and pass immigration inspection, they are admitted into a student status. And that is what allows them to study, be in the United States, or work, whatever it is. So once the person is here in the United States, unless it is traveling and seeking readmission, that revocation has very little value unless the government is trying to use the revocation to build something more. And that's where what's happening in this case is that they're using this revocation of the visa based on national security ground. They did not invoke misrepresentation, not so far. And so what they are trying to say is that we're revoking your visa, which renders you sort of like a question whether you are properly admitted and inspected into the United States, meaning because a proper entry requires not only procedural regularity, which is apparent here, but actually substantive regularity. So what they're trying to is trying to, place or build a case that he really is an inadmissible non-citizen to switch the burden of proof. And so that's when they issue the NTA. There's this weird wording that they put in, which is laughable, but they want to use the visa revocation in order to basically erase retroactively the fact that he properly and lawfully entered and was in student status. And then they want to build on that when the USCIS adjudicated his green card application, which was based on his marriage to a United States citizen, he was not eligible for that adjustment of status because he was not properly admitted, so he was not in valid status. He may have made material misrepresentation, and he is a national security concern. So they're kind of making a very weird breadcrumbs they're laying down to reach a result that is really not supportable, in my opinion, under the immigration statute and under abiding precedent. So I think they're going to be facing a big uphill battle with that notice to appear and in the actual removal proceedings. So once they arrested him, they actually took him into custody. Because he was arrested in New York City, he was transferred to the ICE location at Federal Plaza, which is basically a holding pen. What they did is that they took a photo, they fingerprinted him, they put him into the system, they created what's called an I-213 form, which memorializes the event of the arrest and the grounds for the arrest. And then an officer issued what's called a notice to appear. A notice to appear is a charging document. In immigration cases, the equivalent of an indictment or any criminal information in criminal cases, or your complaint if you're filing a civil case. Because immigration is not a criminal proceeding, it is a civil process. So it has his own rules and issues, but the whole deportation process starts with this notice to appear that is filed by the government, and that vests the immigration court with the authority to decide whether a person can be removed, or even if they are removable, they can be given another status, such as a green card, asylum, or any other permanent relief to remain in the United States. And so the removal proceedings are exclusive proceedings to determine whether somebody can remain in the United States, or if they have a green card, they can be stripped from that green card and physically removed from the United States. That's an exclusive process. So, the Congress had put in a tremendous amount of roadblocks for judicial review, and that is the biggest hurdle for Mr. Khalil. Because what happened is, once he was arrested, he was transferred to New Jersey to the Elizabeth Detention Center, and then because there was not enough space, they're saying, he ultimately gets sent in the boondocks in Jena, Louisiana, which is a the massive detention center run by, I believe it's the Geo Group, a for-profit private company that runs prisons and immigration detention center. And it is really a detention center in the middle of nowhere. And it is has horrendous history, track record of abuse, substandard conditions of detention, and it has detained immigration court within that adjudicate these cases. And so you, as you're a non-citizen, the last place you want to end up is really in Jena. Now, I have to say I have a big bias. I've done many cases in Jena, in another detention facility, but I'm particularly vexed about that location. And what happens and how cases are adjudicated. So that was a horrible thing for Mr. Khalil to be sent to that place, which means that unless something happens, his case will be decided by an immigration court in Jena for the time that he remains detained. Or if he's released, then he can move. But the government is going to fight tooth and nail to keep him detained and have his case decided in Louisiana under Fifth Circuit case law. That was the plan. So Mr. Khalil's attorney obviously are trying to prevent that result, which is kind of predetermined in a certain way. And so what they did is they filed immediately, almost, I believe at 4:40 in the morning on the day he was arrested, what's called a habeas corpus petition with the federal district court in the Southern District of New York, and the case was assigned to District Court Judge Furman. And so a habeas petition is the oldest of the writs, which basically means you pay $5, and if you are detained, if you are in custody, you ask a district judge to decide whether your detention is lawful, meaning is your detention violative of a statute or the Constitution of the United States. And if it's an expedited process that really deals with detention and release, and so if a federal judge finds that the detention is unlawful, then the federal judge can issue a writ directing the jailer to release the person. So it's a very powerful remedy, tremendously powerful remedy, unless you're dealing with immigration cases. Why? Because Congress wanted to eliminate judicial review, including the writ of habeas corpus, to be used for non-citizens to challenge their deportation, meaning prevent the executive from deporting them. And so in order to prevent these multiple venues and avenues to challenge whether a person can remain in the United States, Congress has consistently and perpetually reduced and limited judicial review. And as the law stands right now, pretty much anything related to whether a person can be detained by ICE, whether they can remain in the United States, whether they're deportable, removable, and whether they actually can be removed based on a final order of removal is channeled in the immigration court, an appeal, which is an administrative appeal to the Board of Immigration Appeal, and then a petition for review before the circuit courts. So it is an effort to prevent non-citizen from having additional avenue or additional eyes to look at cases and see and remedy some violation. So to start with, immigrants like Mr. Khalil and everybody else who find themselves in detention are having a uphill battle to use the writ because it is very limited with respect to core immigration cases. And the Supreme Court has done away with a lot of the protections that used to be there. And a lot of the old cases that started as habeas cases, immigration cases started as habeas, are really not good law right now because of a case that the Supreme Court decided recently, maybe probably 10. It was right after 9/11, so probably it's not that recent, but it was Rumsfeld v. Padilla. And Mr. Padilla was a United States citizen who was arrested by military authorities, and he was declared by President Bush a enemy combatant, and he was held on a brig. And so the case started as a court habeas as to whether they can declare a United States citizen an enemy combatant and hold him. And so that is the last pronouncement, pretty much, and of case that is relevant in immigration context for purposes of habeas corpus. And in the Supreme Court, basically, kind of trim down how habeas can go by saying, well, when you can if you're a non-citizen, you can invoke it, you can use habeas, but you cannot kind of use the writ to shop venue outside of where you're detained, which normally is coincidental to where your removal proceedings are going to be held. So this is what Mr. Khalil got himself into. They filed in New York City because, first, it's a friendlier district court. It has a very good case law precedent that the attorneys for Mr. Khalil thought they would be able to use. Because of what they're arguing is that he was detained not because of a lawful reason, but because he is a political activist. And so they arrested him and trying to deport him because of his political opinions and his actual free speech. And they wanted to, I believe, they wanted that case to be in New York City because first, he lives there, his wife is there, and second, there is a case that was litigated that was a huge case that the Second Circuit Court of Appeal, which is the appellate court for New York and that whole area, decided and found that, when free speech is the basis for a retaliatory arrest, immigration arrest, then people have avenue to fight. And that case is called Ragbir, after the name of a political activist who was victimized by ICE several years ago, and who fought back by saying, well, yes, I did have an order of removal, but you really arrested me to retaliate because I am an anti-immigrant and anti-ICE activist. So that's the case law that they want to use, because the remaining case law is not good, because the Supreme Court has, every time that they had an opportunity to opine on it, have said free speech or violation of free speech is not a defense to removal proceedings. So as long as the government has a valid basis to invoke the Immigration Act to remove somebody, like they're trying to do in Mr. Khalil's case, the fact that you are exercising free speech is not a defense to deportation. Ragbir went away from it. Now, of course, it got to the Supreme Court, and the Supreme Court summarily reversed that decision because of another case, which is called Taragassian, which pretty much messed up everything with respect to due process to immigrants. And so the Supreme Court never decided the issue in the Ragbir case, sent it back to the Second Circuit. Second Circuit sent it back to the District Court, and they settled. So we do not have really a binding precedent even in the Second Circuit on that substantive issue. But it is, the Ragbir is still in the books, the Second Circuit decision. So I'm sure the attorney thought that is the place we want to go, because at least you have a step in with a very good argument, a sympathetic a plaintiff here, and perhaps a sympathetic judge. And so we can build and actually make a good law for citizens, for non-citizens, basically safeguarding First Amendment protection to every person in the United States, as the Constitution said, and also in the process fortify First Amendment speech for everybody, including citizens. So they filed the petition in the Southern District of New York. But what they didn't know is that by the time that they filed the petition, that was, I believe, on Sunday morning at 4 o'clock in the morning, Mr. Khalil was already transferred out of Federal Plaza to the Elizabeth Detention Center in New Jersey. Why is that relevant? Well, because it brings in the issue of jurisdiction. And the jurisdiction for purposes of habeas is a little odd, and that comes from that case I told you, the Padilla case from the Supreme Court, where the court says, for purposes of habeas, for purposes of the writ, the jurisdiction, the personal jurisdiction of the district court lies based on where the person is detained, meaning it follows the body, but primarily it is governed by the custodian, meaning who is the immediate jailer of the person, basically who's holding the body that you're trying to release. And the reason for that is that the writ, as it was written, it doesn't act, it's not a plaintiff who's driving it, but it is a mechanism that operates on the jailer. So the court have to assert personal jurisdiction over the actual person holding the prisoner in custody, just jailer or the warden. And so the district court has to have jurisdiction in order to issue a writ and bind that custodian. And so in the Padilla case, the Supreme Court says what you're looking for in habeas for purposes of personal jurisdiction is the immediate custodian. And the immediate custodian is the person who's in charge of the facility where the prisoner is held. So they shut down for what's called court proceedings. Any of the arguments that we used to, as an advocate, used to make is that, well, yes, the detention facility, the county jail, the sheriff or the warden or the whatever, whoever is in charge of the facility is the immediate custodian. But the real custodian, the legal custodian, is the person that makes a decision. And that can be the ICE director, that can be the DHS secretary, could be the president or whatever. And the Supreme Court says no, for court proceeding, meaning proceeding where you're looking to have somebody released from detention, all you care about is the immediate custodian, the actual warden or jailer. So when they end up in the district court on last Sunday morning, they filed thinking that Mr. Khalil was held, the custodian was the ICE field director, Mr. Joyce, in that has jurisdiction over the New York, city of New York. And so that's who they invoked as the custodian. However, he was actually in New Jersey and in a detention facility, the Elizabeth Detention Facility, with a different warden. So that was the first wrinkle. Then, within few hours, and I believe by Sunday morning or midday, he was already taken down to Jenna, and so the actual custodian of the body of Mr. Khalil is the warden or whoever is in charge of the Jenna Detention Center. Used to be called the LaSalle Detention Center. And so that's what the first issue that came before Judge Furman was. Okay, I certainly have subject matter jurisdiction, but do I have venue and personal jurisdiction to decide this case? And so there was a flurry of motions that were filed. And first thing he did, he said, you cannot remove Mr. Khalil. And that was done to preserve the status quo, which is kind of useless thing because as a legal permanent resident, person with a green card, he cannot be removed from the United States unless there is a final order of removal. And so, not really useful, but he put it in. It's a good thing to have so that they don't pull any crap and try to do something that is obviously illegal, but the government can do everything, as they did with people sending people to El Salvador without an order of removal. So that order was a very helpful thing, sort of providing a blanket for Mr. Khalil and his family and the attorneys who represent them. But the issue then becomes what's going to happen. So the government comes in and say, no, because of the immediate custodian and because the Supreme Court decision in Padilla, you, Judge Furman, do not have personal jurisdiction. So you have to transfer the case to New Jersey, because that's when the case could have been filed, when it was filed. Or really, you should transfer it to Jenna, because that's where Mr. Khalil currently is detained. That's when we plan to detain him. And that's when his removal proceedings, immigration proceedings, are going on. Mr. Khalil's attorney came in and says, no, 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 this is a special extraordinary case, and made some arguments that were like trying to push the envelope. The problem for them was that Judge Furman had already decided multiple cases, immigration cases, in which he has found that the immediate custodian controls. So there are few judges that had gone the other way. That was a very hotly debated issue. There was some dissenting judges in the district, but most of them, the majority, have sided, including Judge Furman, saying no, for purposes of core immigration, habeas corpus, it's the immediate custodian that controls. So the moment I saw that, I was like, oh, that's not gonna be good, because unless Judge Furman is going to make a leap of faith and say, well, this is a special case, he's gonna rule the same way. And I'm saying that because I have litigated some cases in New York, and I had managed to convince another judge that the immediate custodian did not apply in my case. It was many years ago, maybe 7-8 years ago. But then Judge Furman decided another case, and my judge says, no, Judge Furman is more persuasive, and I'm going to change my decision. So I knew that this was not going to be very good, but I was hoping that he will create some sort of an exception. Well, fast forward to today. This morning, he issued a decision on the issue of who is the immediate custodian and when this case is going to be decided. And he sided partially with the government, and sent the case to the New Jersey District Court. And the reasoning is, what he said is, the case should and could have been brought at 4:40 on Sunday morning in New Jersey, because that's where he was, and that's when the case hit the electronic filing system. And once it is accepted by the system, it's considered filed. So there was a misunderstanding, and so they filed in New York. But if they knew where he was detained on that minute, the case could have been filed in New Jersey. So I'm going to transfer it to New Jersey. I'm not going to transfer it, as you asked, to Jenna. So partial victory, because between Jenna and New Jersey, I will take New Jersey every day. But it is remain to be seen what's going to happen. I'm not a big fan of New Jersey as a venue for immigration habeas, but we'll see. I haven't done one for a while, so maybe there's some better precedent since that. But reality is, his case has not been transferred to the district court in New Jersey. I didn't see if it was assigned and to whom it was assigned, but the relevance is that now the case is going to be decided under the precedent that applied to New Jersey and not New York. And so different case law, different precedents, and that may be crucial, because the other motions that were filed when the case was still with Judge Furman in New York included a request for Mr. Khalil to be released on bail pending the habeas corpus proceedings, and second, a preliminary injunction that asked for a district court to find that the Secretary of State could not designate him as an individual inadmissible on national policy and foreign relations ground. Now, why is those two motions very relevant? Because the first one is obviously, if granted, will cause Mr. Khalil to be released so he can travel to New York. And with him, the immigration case is going to be transferred to New York. That will be a significant benefit. Not only that he will rejoin his liberty, but physical liberty, but his case is going to be, immigration case will be conducted in New York, where his family is, where his support system is, and where his attorneys are. If it is denied, then the case stays entirely with the confine with the Immigration Act and the Immigration Court. I'll tell you what that relevance is. The second motion that they filed in the district court was that trying to basically kill the immigration case, the removal case. Well, that I think is going to be a very tough road because of the zipper clause and the channeling provision, channeling any issues, including constitutional issue relating to the start of removal proceedings, the deportation proceeding, and the execution of an order of removal as part of the review of the order of removal. So that is going to be a very, very hard road for them to take, but a sympathetic judge may find a way, or the attorney may be really, really, really clever and manage to convince the judge that all the prohibition against judicial review do not apply and somehow are trumped by this retaliatory arrest allegation. We'll see, and I will report back on that. But from the time being, he's going to continue to have this habeas proceeding in New Jersey, and we'll see where it goes. And then I kind of doubt that the New Jersey judge is going to order him released, but we're hoping that he will be. And I'm saying that because, as I said, I don't know the individual. I don't know his family. I don't know his attorney. I have no opinion or knowledge about what he did, what's alleged to have done. But my view is that nobody should be held in punitive civil immigration detention. And that is my core belief. And so I'm biased on that. So I would not want to see anybody detained unless there is a really good reason, such as mandatory detention is invoked, or the person is a flight risk, or it's a danger to self or the community. So that's my personal opinion on that. So I do hope that he will be granted a bond or he will be released. But if they're not successful in the habeas, that's going to be decided by an immigration judge, because Mr. Khalil is an admitted non-citizen, meaning he has gone through inspection when he was in student status, and as such, he's entitled to a bond proceeding before an immigration judge. Problem is that once either the terrorist, the three grounds, or the national security grounds are invoked, those cases are considered mandatory detention cases. And so the attorney representing the government, which is the Office of Principal Legal Advisor of ICE, or we could call him OPLA, will be arguing that he is a mandatory detention kind of case, and meaning that the immigration judge does not have legal authority to release him regardless of the equity that he has. He obviously has tremendous amount of equity. He came legally with a visa. He does not appear to have criminal records, at least none has been recorded. He has a wife who's a United States citizen. She's pregnant. He had held a job. They're expecting a child. He's a person of good moral character. They're going to argue. Now, you may disagree with that, but that's something that can be argued. So he has a good, tremendous amount of equity, which generally would tip the scale in favor of a bond. And so unless and until the government can convince an immigration judge that Mr. Khalil is a mandatory detention kind of case, I would think he will be eligible for a bond and he will be given a bond. Now, these days, immigration bonds are much higher. We used to get in the old days, it was normal to release somebody at $1,500 to $5,000 these days. I see a lot higher bonds, so he may be subject to a higher bond, and a lot of time, bond of $50,000. I've seen bonds of $150,000 lately. Those could be really not possible for people to post. I don't think that's going to be the case with Mr. Khalil. So as long as an immigration judge gives him a bond, he will be released. Question is he gonna be getting that bond? So, we'll wait to see. I believe he has an initial master hearing scheduled for March 27, and that is going to be basically a pleading on the notice to appear. But I expect or presume that the attorneys have filed a request for a bond. And so even if they invoke the mandatory detention provision, he should be entitled to a hearing for an immigration judge to decide whether he fit within the definition that he's a national security. And so maybe something will come up during that process that shows that Rubio has not invoked the procedural ground that he has to. They didn't follow, and so the whole thing will fall apart. Hoping for that, as I said, because it's an extraordinary case, and it appears that there is a lot going on by the government trying to use him as an example for a new policy and as a deterrence, and that should never be used by the government. That's my opinion. So I have a bias. I feel like I have to disclose the bias because I'm not trying to slant, but it's difficult to not, give your opinions the way you've seen it. I've been doing immigration law for a very long time. And obviously, I'm not a big fan of ICE, and I'm not a big fan of the immigration bureaucracy because they're just awful. They're incompetent, and they are malignant, and they are malicious often. So, personally, I'm not. I always say, you can never trust any document that is filed by ICE, and you always verify, because if you dig in, you're going to find out that there is some procedural irregularity and sometimes major violation that are lurking in the back. And we know that's the case because if you look at the notice to appear that they filed, the charging document, this is the most ridiculous documents I've ever seen. I think I posted it on Twitter, so if you go and I think the Washington Post had it. So if you are interested, you can find it, or it's on a court docket for Mr. Khalil case. It's an exhibit, I believe. So it's part of the public domain. I mean, you would think that a case of this magnitude, that they, by their own word, were building as an example, as the blueprint for how they're going to go after student protesters and others who espouse views or political opinion that the administration does not agree with. I mean, you think that they are going to spend a little time to make sure that the document at least looks presentable. They didn't do even that. I mean, they put in the most ridiculous thing in the factual allegation, which is the same thing, the same 4 or 5 factual allegation that is in every notice to appear. Any officer who has issued an NTA has issued them, million times before, so they know what to put in. In this particular case, they put in that although Mr. Khalil was admitted into the United States as a student status holder with a visa at the time, they put in that he entered the United States on an unknown time, in an unknown manner, in an unknown place. I mean, you do not put in that somebody is admitted and then try to put the allegation that you put for somebody who entered without inspection, which basically run through the border. I mean, these are two basic stuff that you don't do. Then in the same sentence, they went in and said that, or he obtained his green card in violation of the prohibition of inadmissibility, the inadmissibility provision that they're invoking, that he is a national security threat. Now, clearly it was a typo. They meant to say you obtain your green card in violation of the provision that prohibits people who are national security threat to be admitted into the United States. But, I mean, do you really need to be so sloppy and not even check to see that you put in a cogent factual allegation? I mean, it's nitpicking. I get it. Most people will say, well, they were rushing. But why are they rushing? I mean, they've done that bazillion times. They know it's a high profile case. They knew it at the time. They knew that's going to be plastered all over. So it just, that's what they do. I think they're sloppy. They're entitled. And, that's good for us because you can hang your case on some procedural irregularity, and sometimes it works very well. But they knew that this case is going to be fought very hard, and then it went in and put it. I think they were trying to flood the zone. That's what they've been doing, and this was like a rush decision. Maybe the surveillance has just happened. I don't know, but it is really ill-conceived case. And the only explanation to me is that this case was not handled by the enforcement unit. It's not an ICE, but it was driven entirely by the White House. Maybe Stephen Miller or somebody who was basically barking orders. But this is not, from what I've seen, the way they put things together, this does not appear to have run organically the way targeted arrest happens. And this was, I believe, a weekend. So it's a lot of stuff that do not match, but it fits perfectly if you accept or you believe that this was an orchestrated case, a test case, to build basically a precedent, to test the water so that they can go after certain people that they wanted to go after. And they have been putting in on X, from the Rubio's account, the press secretary, DHS, everybody saying that if you espouse opinions or you support organizations that have been designated as forest terrorist organization, we are going to prevent you. We're not going to give you a visa. And if you got the visa by lying to us and concealing the information, we're going to go and find you. And trust me, they have actually put that in practice. I mean, the few cases that are publicly disclosed are there. We know that there was another Colombia student that self-deported. Her visa was also revoked. This one is different. She apparently, the basis for it was because she got a citation during the protest. It was a criminal citation. Case was dropped. She renewed her visa, probably in Canada or wherever she went, and didn't disclose the arrest. So they used that to revoke the visa. She self-deported. There've been several cases in which people returning to the United States with valid visas have been revoked, and people have been deported. Some people are in detention based on allegations of support for terrorist organizations, sympathizer for certain causes, or failure to disclose information on visa application pertaining to political views, political affiliation, political membership. And on its own, that's not necessarily new. Visas have been revoked in the past. It happens often. People with visa have been denied entry. Nothing new there. People who are denied entry get detained. If it's an airport, there may be not a possibility to turn around, put them on the next plane. People get placed into detention facilities. There may be delay. It could take up to months before people are deported. Nothing of that is new. I want to make sure. What I find suspicious and what I find as being a new trend is the targeted efforts to revoke or deny entry based on prior failed effort to vet people, what's called the administrative in the AP, administrative proceeding at the visa level. And so what appears to me, based on reported cases and the cases that I have handled over the last 5 weeks, and I'm not going to go into those cases because of attorney-client privilege, and I don't want to disclose any information. So that's why I limit my blabbering to disclose cases and cases in a public domain. But what I keep seeing and what I'm concerned is emerging as a trend is that they are using AI to look for student protesters, people who were involved in these protests last year, and who may have had disciplinary proceedings. And so they're using AI to match and find non-citizens. And then they're using administrative proceedings during visa processing, AP eligible cases where people have, for whatever reason, have been subject to additional vetting. And so even when they have received their visa, meaning that they successfully cleared AP, at inspection, at primary inspection, the officers now are looking for the visa history. They're looking for people who have been in AP, and then they're flagging those cases if they fit within particular profile, and they are sending these people to secondary inspection for searches of phones, searches of laptops, searches of belongings, in order to find information or build their cases that people have misrepresented affiliations. And that is something that is unusual. It always, I mean, people, officers uncover derogatory information during visa. People admit things. That's nothing new there. But it is appeared to me so far that it's whatever directives have been given by the Secretary of State and DHS, they are going after a profile of non-citizens seeking admissions or who have already been here. And they're going from that profiling down to find a reason to invoke removal proceedings. And if that is the case, and if I'm correct with that, that is an emerging secretive policy that is definitely unlawful. But it remains to be seen and what's happening. So, it's a lot of going on, a lot of issues. And so if people are non-citizens, as I said, until you hold your naturalization certificate, ICE can go after your status. So be very careful. And as I said, if you are planning to go, you have a status, student status, work status, whatever, and you are planning to go overseas to get re-stamped, meaning to renew your visa, think twice. We're seeing a tremendous change in the way consular officers are now processing, and I anticipate that it's going to get worse from now. And then even if you manage to get your visa, you don't know whether you're not going to be selected and possibly put through the ringers because of something that you have on your phone, or a meme that you may have retweeted, or something in your social media that doesn't seem palatable to whoever is doing the inspection. So again, everybody has, in my opinion, every person in the United States have First Amendment rights. Unfortunately, the Supreme Court is erring on the side of saying that exercising your free speech is not a defense for deportation. And that opens up a lot of possibility for abuse and a lot of possibility for officers and certain members of the executive to use that discretion to penalize people for their views and do it with impunity. So cautionary tale, and I think an unfortunate one, but it's something that is going on. And then, of course, I blabbered too long about this case and went places I didn't plan to, but hey, that's what happens. But I wanted to circle in because I got some questions about the abomination that is going on with the people the 300 or so people who got basically deported without any compliance with the Immigration Act, Title 8, and sent to El Salvador and put in a high security prison that is notorious for abuse and torture. So a lot of people sent me requests. I had called for people who are looking for their loved ones and fear that they are among the 300 people. So it is a horrible situation. And so I'm pretty sure nobody who's looking for somebody is looking at and listening to this stream. But I know people were interested because it's a highly politicized issue and the emotions are high on it. So first, what I wanted to answer is questions that are as to the law or whether something complies with the way I read the Immigration Nationality Act and the Alien Enemy Act. But it is my opinions. They are neither, they're not, I'm not saying they are right. They're just my opinions. And so if you care to stay and listen, please do. If other than that, it's just my view of the facts. So reality is that the Alien Enemy Act is on the books. It's a relic. It's been used during wartime several times to cause tremendous amount of trauma and penalize and victimize people and violate their rights. And Congress never repealed it. So it's on the books. However, what we also have is Congress have created a comprehensive scheme for anything immigration in the Immigration Nationality Act, or what that you may hear somebody refer as Title 8. So now the effort of President Trump to invoke the Aliens Enemy Act is just an overreach and is just, it's kind of laughable, but Stephen Miller seems to be enamored with the idea. He was enamored with the idea at the end of the first Trump administration, but Mr. Miller is not a lawyer, so I don't think he has any idea or cares as to what precedent says or how courts have interpreted certain statute, provision, or procedure. He goes by what he thinks. But so judges will decide whether it is permissible, and ultimately, I anticipate that the Supreme Court will take the case and decide. I will be shocked if they sanction the use of the Alien Enemy Act without a declaration of war and against a terrorist organization that is a non-governmental actor that is swing as like a gray economy, kind of a set arm of the Maduro regime without any proof of that. And so I think it's really far-fetched, but I'll talk to you about that another time. But what they did is they had about 120 people with order of removal, final order of removal, which could be executed. And so this is one of the planes. The third plane was people, they claim, people who had final order of removal. Now, I haven't seen any information as to the nationality of those people, but my suspicion is that they're not citizens of El Salvador, but they were Venezuelans, so they cannot be deported. They were not being deported to their country of origin, but maybe that's not the case. But then we had about, I believe, 137 or so people who did not have a final order of removal. Some of them had immigration court cases already. Some had dates. Some had filed asylum application, from what I understand. Some of them had entered with the CBP-1, and so they had been paroled in the United States during the Biden regime. And so people were still in valid status, had work authorization, and were picked up, and they were designated as TDAs, a member of the Tren de Agua criminal organization that Trump designated as a foreign terrorist organization. And so based on that membership or suspected membership in the gang, they were put on a plane and they were summarily deported. I mean, physically flown to El Salvador and put in the SECOT, that high security terrorism prevention prison in El Salvador that can hold up to, I believe, 40,000 prisoners. Now, that's where the president of El Salvador detained a lot of the members of the Maras, MS-13 members, criminals, etc. So the prison has, horrendous track record of human rights violation, but has been used in the combating criminal activities and the gangs in El Salvador. So that's what happened. Now, the legal issue here in the case that is, I believe, called JGG, that is pending before Judge Bosberg in the DC District Court, is whether this is impermissible, whether you can, without going through the removal proceedings, without allowing people to challenge the designation as being member of a terrorist organization, here it's a gang, they to be just removed to a third country and put in punitive detention. And from the reports, the Trump administration had paid El Salvador $6 million to keep these 300 people, 250 people for 1 year renewable. Now, that is definitely nothing permissible. Nothing like this is permissible under Title VIII. And they're not claiming that it is. What they're claiming is we could do that in the exercise of the presidential authority as a commander of chief and in conducting foreign affairs. And as such, he can invoke the Alien Enemy Act at any time, even if there's no act of war, as long as he thinks that there is invasion or predatory invasion, which he put in an executive order. So they're basically saying, well, because he already determined that there is an invasion, and because he, based on that invasion, stated in an executive order that the gang, the prison gang, the Venezuelan prison gang, is part of the Maduro regime, meaning it's an arm of the state. They are basically a government. And so I don't need to invoke the war powers. I can just invoke the Alien Enemy Act. Well, this is a lot of circular reasoning here, and as a catch-22, you can never get out of it. But that's what pretty much they are trying to argue. Now, the case that the ACLU brought before Judge Bosberg started as a habeas petition on behalf of 5 individuals, 5 nationals of Venezuela, who were detained, who had been designated as gang members, and they were fearing that they're going to be deported. And the ACLU got leaked information that the proclamation invoking the Alien Enemy Act has been published, and so they were able to file the court. Judge Bosberg right away put an order, a TRO, saying you cannot remove these 5 plaintiffs, and said, I'm going to decide whether there's a class. That was very weird for him to do about the class, because I think there is a very split authority whether you can have a class habeas and to how much you can use class habeas, but doesn't matter, he did it. Now, the government has said the 5 plaintiffs have not been removed and they will not be removed. But their position is you judge have no authority to look into what we did with respect to these other individuals. And that included, in addition to the 120 or so people with final order of removal, 100 or 200 something people who were designated or been identified by the administration as a member of the gang. There were also some 23 people who sounded, based on the release, the press release, were special requests by the president of El Salvador. He wanted these people deported, and they deported it for him, plus 2 gang leaders of the MS-13 Mara that again were extradited. I mean, a lot of time the government will use immigration removal proceeding in order not to go through the formal extradition process, but this is not even immigration proceeding. So there's a lot of irregularity here, but I don't think anybody is looking into that aspect of it at this point. At this point, the fight is whether the government can do what they did, and now Judge Bosberg is going after them because he wants to know if they violated his order during the hearing and over the weekend, where he said nobody can be deported or sent outside of the United States based on a proclamation and the invocation of the Alien Enemy Act, or if some planes are in the air, because they kind of told them pretty much that during the hearing. He said if there are any planes that are in the air, then you have to turn them back. Now, government did not turn them back. Obviously, they put all these videos of the abuse of the prisoner, people being shaved, being shackled, being held, and abused into in public view for voyeurism, to satisfy this effort to show and drive the message that if you deport yourself, then you prevent from this happening to you, which is again sort of appalling approach. But they put that because they wanted that to happen. And so their position now is, Judge, your orders did not matter. First, they came and said, well, the planes were already outside of the territorial airspace of the United States, so your orders do not carry past the air boundary of the airspace of the United States. Then they came and say, well, you didn't put it in the final written order, you just put it during the oral hearing, as an oral order during the hearing, and the people who heard it were still in the hearing. They have no chance to convey that to the defendant, so you cannot basically do that. Now, this morning, it seems that they come in and they have said, well, regardless of whether we violated or did not violate your orders, we are not required to tell you anything or disclose any information that you're asking, because this is a state secret. Meaning, there's a doctrine that says if they are such a sensitive information that goes to war and peace and national security and foreign affairs, then government can refuse to disclose that even to a court, even in camera, meaning without the plaintiffs looking in, without the public's having access to this information. So they clearly are not wanting to give the facts to the judge because two things are possible. One, they really believe they are not entitled and they're setting up the issue for Supreme Court review. I kind of doubt it, but that's a possibility. Or they lie to the judge by telling him that the planes were outside of the United States and that they didn't have the authority to turn them back, because if they lied or if they didn't follow his order, technically he can invoke his contempt power and can place people in contempt. Now, who can he put in issue a contempt order against? Well, he can hold the attorneys who appear on behalf of the government in contempt if they lie to him. Judges will not be very keen to do that. The question is, ultimately, the reason why this thing happened has nothing to do with the attorneys who showed up to court, who are representing the government, but it has everything to do with what the higher ups, Stephen Miller, Homan, and whoever is in the entourage of President Trump that wants this to happen, made this decision and orchestrated it and hid the information, hid the proclamation in order to get this plane on the ground in El Salvador before the information hits the media and X. So, question is then, if that is the case and they clearly defied his order and they'll continue to defy the court's order, can the judge hold in contempt the head of the agency? I mean, question here for me is, can he hold in contempt the Secretary of State, the Secretary of DHS, or the acting director of ICE? I don't know. I don't think that it's been done before, probably, but the question is, can he do that? And if he does, I mean, that's going to be a major, major issue. I mean, is he going to throw him in jail until they give him the information? I mean, that would be a spectacle. I don't kind of doubt. So at this point, I think the government is playing chicken with the court, hoping, one, that the DC Circuit is going to come to the aid and they're going to say the judge didn't have the authority to issue the temporary restraining order that he did. And not because he was acting outside of the law or that the Alien Enemy Act cannot be invoked, but because he didn't give enough notice and an opportunity to be heard to the government. And so if the TROs are stricken, then the only thing the judge can, continue to dig in is whether there were misrepresentation made to him in court. So there is some legs to that, but I think it seems to me that the government is trying to prevent the disclosure of any information because the facts are not what they've represented or intimated they are. We'll see. I'm sure that there will be some development in the next few days. I think the DC Circuit should issue a decision on their request for stay. I think they filed two of them, an appeal and two for both the initial TRO and also the class TRO. So I expect that they will rule. They have asked for a response, and maybe it should be done tomorrow, but by the end of the week. And then they can take it to the Supreme Court. I think, based on the way the Supreme Court responded to the birthright citizenship executive stays, I don't think they're in a rush to step into this. So it could be that we'll get denied stays. So everybody is going to be, the court will be given an opportunity to ventilate and see how they come and what they develop as a record before the Supreme Court ultimately takes it. But that's going to be probably a while. They're going to be going on a cert, that's probably going to not be accepted until next October, meaning if they are outside of the emergency docket, the regular docket is not going to be until October that a cert could be accepted. And then even if they rush it, we're probably not going to hear something until late the year. So a lot of time will pass, a lot of things will develop until then. I think at this point, the administration seems to be very careful or very deliberate in only seeking partial issues to litigate in a stay and possibly get on an emergency docket, but that may change at any time, so who knows. I think it's interesting from a legal standpoint. I think we have a lot of interesting developments going on, but at the same time, it is a very, very trying times for immigrants. So, in a way, it's people were interested in immigration, and it's nice. But at the same time, there's a lot of voyeurism going on, and people want to express their opinion and criticize. But a lot of time, people don't realize that if you put aside all the political issues and your own views or where you come on the issue of immigration, it doesn't matter. The people who are the subject of these policies are people, many of them who have no criminal record, people who have been here for a long time, people who have family members, immediate family members who are United States citizens, who have tried to live the American dream, but they simply do not have a way to legalize their status. And so when draconian policies are put in place, these people and their families suffer tremendously. And so this seems to be left, forgotten by a lot of people who feels and have very strong views on immigration, and a lot of time will, troll people and express very drastic views, and that's their right. But if you can bring yourself down from the rhetorics and understand that the people who are driving these posts and these media reporting that are meant to get a lot of clicks and a lot of views really are people just like all of us, and people who a lot of time the only thing that they've done is that they overstayed the visa, or they enter illegally in the hopes of living the American dreams. And is that an excuse? No, it's not an excuse. But at the same time, they don't deserve to be victimized simply for those mistakes or the mistakes of their parents, and to be put through, you know, measures and conditions that are there just to punish. And I think that's where my biggest objection is. And I hope that we will stay away from it, although I don't think it's the case. And I think we're going to see a lot more unseemly things. But, anyways, I probably depressed you enough with this stuff. And I apologize. I think I ran away out of time and I have things to do. So I will keep the questions. I got some questions and I like to answer those questions, but I will try to do that. I will do a follow up maybe over the weekend and I answer your questions. So if you happen to pass and listen to this stream and you have any questions, hit me up and I'll try to answer it. See you maybe on Saturday. Bye, guys.